Welcome to our video on auditors' legal liability, and I'm going to look at specifically the legal liability of auditors in Australia today. So if you are in another jurisdiction, so if you're in the US, the UK, anywhere in Europe, you'll need to double check the precedents that apply. Because here I'm just looking at legal liability specifically for Australia. So I'll start with our sources of legal liability. And so as an auditor, we produce an audit report. And that's a document that's publicly available. So because our information and our work is out in the public domain, that does expose us to some legal liability. And so we have three sources of legal liability. And so our first source, number one, is regulatory. And so our regulation here in Australia comes in a number of different formats. The first piece of regulation that we have, let me get my pen, is the Corporations Act. So the Corporations Act in Australia is a Commonwealth regulation introduced in 2001. And our Corporations Act covers a number of different things. It covers the work of auditors. It covers the work of accountants, and it also covers the responsibilities of directors. So anything to do with a company, setting up a company or a registered entity, reporting requirements. So work for auditors, accountants, and directors is covered under the Corporations Act. So as auditors, we have specific responsibilities under the Corporations Act. And those specific responsibilities include being independent. It also includes performing an audit in accordance with the auditing standards. And also making sure that we provide an opinion about whether the financial statements are true and fair. Our accountants and directors have responsibilities towards preparing the financial statements. And the Corporations Act clearly states that it's management's responsibility. What's our second piece of regulation that auditors are exposed to? That is the Competition and Consumer Act. Again, that's another Commonwealth piece of legislation from 2010. And this is a replacement for the old Trade Practices Act. And so the requirements of the Consumer and Competition Act are fairly clear, and this covers all products and all services, is that a party cannot engage in misleading or deceptive conduct. So that means that if the auditor intentionally or ends up misleading or deceiving shareholders because of what is included in their audit report, if their audit report is incorrect, is exposed to liability under the Competition and Consumer Act. So I've looked at regulation. Let's look at our second point for legal liability, and that is contract law. All right, so contract law clearly states that a contract is between two parties. All right, they can only sue on matters in the contract. All right, so for an auditor, who are the two parties? Well, our two parties are quite easily the auditor and the client. And that client is represented typically by the board of directors in regards to signing our contract. And our contract in auditing has a very specific name. And that name is an engagement letter. So the engagement letter is the specific contract for the auditor. And it's so important that it even has its own auditing standard. So ISA, which is the international standard, and the equivalent Australian standard is ASA 210, terms of the audit engagement. And that very clearly sets out the responsibilities of both the auditor and the client. So when we think about our two parties, the auditor has certain responsibilities, and then so does the client. So what are the auditor's responsibilities? Independence, following the ASAs, applying their professional skill, all right, and providing the audit opinion on time, so the report on time. What are our client responsibilities? Well, our clients have responsibilities to provide access to evidence. And that evidence could be documents or it could be people. They have a responsibility to be honest and truthful in their dealings, not hold anything back. And then very lastly, they have a responsibility to pay the fees on time. So under contract law, only the auditor or the client can sue each other based on matters within the contract. So let's move over to our third section of legal liability for auditors. And our third section is the tort of negligence. And our tort of negligence comes out of the common law. All right, so tort is a common law concept, which means that our law comes from decisions made by judges. All right. So what sort of things do I need to consider? And obviously with the tort of negligence, there's a little video playlist on legal obligations on our YouTube channel. And so it starts with the original case. I hope I got my spelling right here. Donahue and Stevenson. And if you look at Donahue and Stevenson, the case is about a snail in a ginger beer bottle. And essentially, the case said that auditors or anybody who produces a product owes a duty of care to produce something that is acceptable for its end use. So that's our tort. So when we think about auditors, there's a number of different cases, but in terms of the tort of negligence, I'm going to give a summary. In a separate video, we'll talk a little bit more in detail about cases. But for the tort, there are a certain number of rules. So rule number one, or guideline number one, is that the auditor must owe that third party a duty of care. Number two, the auditor has to have been negligent in their duties. Number three, there needs to be causality, which is sometimes called cause and effect. So that means that the auditor's negligence had to have resulted in an incorrect audit opinion, which resulted in the third party's loss there. So we need to have causality. We need to consider whether there is any contributory negligence. Was it just the auditor's fault, or was there anybody else involved? And then there needs to be financial quantifiable loss. All right, so for an auditor or for a plaintiff, so for any third party to successfully sue the auditor, they must meet those 5 conditions. Now, who might a third party be? A third party could be a number of different people. It could be shareholders, it could be lenders, it could be customers. All right. Any third party has the ability to sue the auditor under the tort of negligence. So for that lawsuit to be successful, first we have to determine whether the auditor is owed a duty of care. Second, whether the auditor was negligent. They didn't act with reasonable skill and care. So did not act with reasonable skill and care. There had to have been causality. So the auditor's negligence resulted in the incorrect opinion. There has to be contributory. There might be contributory negligence. So that's only optional, it's not always there. So the management might have contributed to the auditor's mistake. And then there has to be financial loss. So we don't have any damages for emotional distress. So for a third party to successfully sue an auditor, they have to meet those 5 conditions. That means that if the auditor does not owe the third party a duty of care, then we don't need to worry about any of these other instances. Now, I'll create a different video on duty of care. So there'll be a separate video because duty of care certainly requires us to go into a bit more detail and case law, whereas this is just a general overview of legal liability. So who can sue the auditor? Under regulatory requirements, ASIC has the ability to prosecute the auditor under the Corporations Act. Any person really, but generally the Australian, the ACCC, our competition body, will pursue lawsuits under the Competition and Consumer Act. Contract law, only the auditor and the client can sue each other. So under contract law, the shareholder cannot sue. And then we have our tort of negligence, which is for third parties to attempt to sue the auditor. Hope you enjoyed this overview of legal liability within Australia. Keep an eye out for our other videos on duty of care for auditors.